Chapter 2, Biographical, 1780 to 1836. Advocate Judge is the title of the chapter. We now see Scott starting on a professional career as an advocate in Doctors' Commons. This legal nest of civilians was a quite quiet spot under the shadow of St. Paul's on the southern side of the cathedral, with an entrance from Knight Rider Street. There were gathered the advocates, a group of some 25 doctors of law who had in early times been formed into a society, and were, in 1768, incorporated by royal charter under the title of the College of Doctors of Law, exercent in the ecclesiastical and admiralty courts. Here were the business chambers, but sometimes an advocate would occupy an entire house with his family, as did Lord Stowell. Here, too, were the offices of the proctors, also limited in number, or, as they would now be called, solicitors, though they were not admitted to general practice. The pleasant group of brick buildings with stone quoins and dressings dated from 1762, erected on the site of Mount Joy House under a perpetual lease granted in 1570, the first buildings were burnt down
in the Great Fire.
And for a time the Doctors' Commons, or the doctors, made an Exeter House their home until their new habitation arose. Doctors' Commons had a collegiate appearance with its two quadrangles. In one was the library, and hard by was the hall, which served as the courthouse, not only for the Admiralty Court exercising its instance or civil jurisdiction, but in addition, in time of war, its prize jurisdiction. Within it were held also the consistory court of the Diocese of London, and the courts of the province of Canterbury, in which doctors of law and the proctors were practitioners. Few men can now be living who were familiar with this interesting portion of vanished London, but from the description of one who knew it well in the days of Dr. Lushington, an accurate picture of the interior of the hall when Stowell held his court within its walls can be obtained. The judge occupied an elevated seat at the upper end of a room panelled with oak. On the walls hung the coats of arms of the advocates. Below the judge was placed the mace or silver oar, and on the other side were seats for the advocates, each having his allotted place. Beneath sat the proctors at a long table, which extended at right angles from the bench. At the lower end of it was a seat for the registrar, or his deputy, behind whom a few spectators were sometimes to be seen. A touch of colour was added when the King's Advocate and the Admiralty Advocate were in court, in the scarlet robes worn by doctors of law. Doctors' Commons was a close borough in which much important business was decorously transacted, and which, as readers of Horace Walpole's letters know, was the last scene of many of the fashionable scandals of the time. The inclusion in it of the Admiralty and Prize Courts seems at first sight singular. To understand it, we must carry our minds to the 14th century, to an age when there were no commissioned warships, and when owners of private vessels seized the property of belligerents and neutrals alike, whether ships or cargoes, with equal zest. We have also to picture an admiral of the fleet, who, from his position, became an arbiter in maritime disputes. If an instance were needed, one might note the fact that in 1357 the King of Portugal complained that an Englishman had removed Portuguese goods from a French ship which had previously captured them. The answer of Edward III is that our admiral has judicially and rightly determined the ownership of the goods claimed by your merchants. This is the first mention that has been found of judicial proceedings before the admiral. It marks the beginning of the Court of Admiralty as a prize tribunal. For 2 centuries after this date, there are few indications in the records of its prize jurisdiction. Cases usually came before the council or the chancellor or commissioners ad hoc. Formal legal proceedings for prize were, therefore, probably very rare. It was at least 3 centuries before disputes as to prize were generally brought before the High Admiral's legal deputy, and it was not until the 18th century that all cases of prize came before the court. But once the legal germ existed, it required only opportunity to grow into more ample size. In 1498, in a treaty with France, it is provided that all prizes shall be adjudicated on by the admiral. This is one instance only of a more general recognition of the admiral as a judicial personage. But as soon as this high official deputed his work to a lawyer, a regular tribunal was in time evolved. This gradual evolution can be illustrated by a letter of Sir Leoline Jenkins in 1666 to which Lords Commissioners of Prizes, in which he tells how the master of a Riga ship had been barbarously treated by the captors in order to obtain evidence favorable to them. He concludes, "Thus I have given your lordships an account of the pretensions of the one side and of the other, as minutely as I can. In regard, this business is devolved to your lordships from His Majesty in Council. But I do suppose the privateer will insist upon the title he has to a legal trial, which, as I humbly conceive, cannot be denied him." This letter seems to point to an informal investigation in the first place by Lords Commissioners of Prizes, and if this was not satisfactory to the captors and the claimants, then to a formal trial before the judge of the Admiralty Court, who at the time was Jenkins himself. As for the judge, he was, at first, merely a substitute for the higher official, as in a case in 1389 in which one William Toomer is spoken of in the records as substitute and deputy. But so soon as we realize that the deputy of the admiral became, in time, the judge alike for prize and for marine disputes, we grasp succinctly the history of the Admiralty Court. For as the prize court was also the Admiralty Court, and the prize jurisdiction, one which was only in being in time of war, the history of the prize court and of its judges is necessarily the same as that of the Admiralty Court at certain times in our history. But there was this fundamental difference between the jurisdiction of the judge in regard to admiralty and to prize matters. He could only exercise this latter jurisdiction after an appointment by the Crown, the captor's right to prize money being derived from the Crown. The Crown decided what was and what was not good prize. Orders or commissions to try cases of prize were therefore constantly issued, and in time a practice was established by which, at the commencement of war, the Crown issued a commission which required the judge of the High Court of Admiralty to proceed upon all manner of captures, seizures, prizes, and reprisals of all ships or goods which are or shall be taken, and to hear and determine according to the Court of Admiralty and the law of nations. Because it was by the law of nations that the prize court was guided, and because the Admiralty Court was guided in its earlier days by ancient maritime customs and ancient maritime codes, and not by the common law of England, the High Court of Admiralty was never one of the ordinary municipal tribunals, one of the King's courts at Westminster, administering the common law of England. The practitioners in it were therefore civil lawyers, and from among them the deputy of the Lord High Admiral was selected. At first, without a fixed abode, the court in time became more and more localized. At one time in the old church of St. Margaret, Southwark, and then, about 1675, it was finally established among the civilians at Doctors' Commons, after they had secured permanent quarters in the city of London. Stowell's reputation at Oxford had preceded him to Doctors' Commons, and he sprang at once into a considerable practice. This rapid rise could hardly have occurred, even in a small professional circle, to a man who was without the personal and intellectual influence which this eminent civilian had already attained. It was but 2 years after Scott first appeared in court that he was appointed Advocate General to the Admiralty, an office which gave him the right to appear professionally for the Admiralty in suits to which it was a party. In the following year, 1783, John Scott, his brother, wrote of him, "His success is wonderful, and he has been fortunate beyond example." This short space of 3 years at the beginning of Scott's professional life is an epitome of his entire career as an advocate. He was in constant practice. He was paid large fees, and in his quaint fashion he used to carry to his bedroom at night for safe custody those fees which he had received during the day. Lucrative offices, open only to civilians, were bestowed on him, which are stated in detail at the beginning of this volume. It was, therefore, almost a matter of course that he should become the successor of Sir James Marriott in 1798, as Judge of the High Court of Admiralty, and as Great Britain was then at war, Judge also, by virtue of his office of the British Prize Court. The domestic atmosphere of the court in which Sir William Scott practised was not one which stimulated advocacy to a high pitch of eloquence or passion. What little evidence there is on the subject makes one believe that Stowell's manner was conversational, his matter substantial, and that towards the end of his career at the bar he was sometimes rather overbearing. The manner of Doctors' Commons has perhaps become traditional, for one seems to recognize in Stowell the same characteristics as have since been noted in the courts which are the successors on that in which Stowell practised. He was clearly more suited by temperament to a seat on the bench. He had what is called a good presence, a fine face, and a dignity of manner as he presided over his court, which were lost when he left it, for his short and rather stout figure was ungainly, and we are told by a practitioner in his court that he had a waddling walk like a duck. Nor was he particular in his dress. One likes therefore to think of him as the judge rather than in any other sphere of activity. Sometimes in his speech, even on the bench, he recalled his northern origin by his occasional provincial accent, and turned his E's into A's. The marchant in the case, he would say, and he once observed to a practitioner whose methods he did not like, that we want none of your jarsey tricks in this court. He had a kindly feeling for those who practised before him, and from time to time entertained a party of members of his bar to dinner, and then, seated at the head of his table, pleased his guests by his admirable conversation, of which, however, the younger members of the party, who were at the lower end, heard only precious scraps and fragments. 2 episodes in Stowell's personal life deserve a brief mention. His first and second marriages. The first was in 1781, when he married a lady who was co-heiress of John Bagnall, Esquire, of Earley Court, Berkshire. She is now for us a name only, but it was in all respects a fortunate alliance for Stowell. In her right he became the owner of the pleasant estate of Earley Court near Reading, with a moderate-sized house within easy reach of London, and which henceforth became his country home. However, in his second marriage, Stowell made the one mistake of his life, and this demands a few lines of notice. On December 16, 1812, the Marquis of Sligo, a young man of 22, was indicted at the Admiralty Sessions at the Old Bailey for seducing 2 seamen in time of war from a king's ship to enter his service on a brig, with which he was about to cruise on the coast of Greece. He pleaded guilty, and Stowell, in his dignified way, passed sentence, fining Sligo £5,000 and ordered him to be imprisoned in Newgate for 4 months. After this trial, through the intervention of an aunt of the boy's mother, the Marchioness of Sligo, and a friend of Stowell's, he became acquainted with this lady. Within 4 months they were married. The event caused no little amusement in London society, and was unfortunate for each of the parties. The wife was generous, and the husband parsimonious. The wife liked her evenings at home. The husband preferred the society of the club and of his legal friends. Of their short married life we know little, but it is certain that the marriage was not agreeable in its outcome, and Stowell and his wife became estranged. Lady Sligo died during a visit to Paris and Amsterdam, while Stowell was making a tour in Switzerland. One almost forgets that for 31 years Stowell was a member of the House of Commons, for in those days the Judge of the High Court of Admiralty was not ineligible for a seat in Parliament. It is sufficient to say that he was a strong Tory in politics and a close attendant at Westminster, and that he never intervened in debate except on some one of the rather technical subjects of which he was a master, or in which he was officially interested. He was created a peer on the coronation of George IV, taking his now historic title from an estate which he had purchased in Gloucestershire, and which, by the way, turned out an unprofitable investment. But it gave him a name which has become historical. Stowell outlived most of his contemporaries, and consequently became the oldest member of the Immortal Club. But after he retired in 1828 from the bench of the High Court of Admiralty, with which he is permanently associated, he lived for the most part quite quietly at early court, his fine intellect much impaired by age. His daughter, the wife of Henry Addington, afterwards Lord Sidmouth, was his favourite companion. She had many of her father's gifts, and Mary Russell Mitford has left a very pleasing sketch of her. "I have," she wrote, soon after Lady Sidmouth's death, "seldom known any one more thoroughly awake and alive to all that was best worth knowing. She had an enlightened curiosity, a love of natural history, of antiquities, of literature, of art, was herself full of talent, intelligence, gaiety, and had a quick and peculiar humour." Stowell remained also on terms of affectionate confidence with his brother Lord Eldon, by whom he was often visited. It was in his pleasant country home that Stowell died on February 28, 1836, many years after his memorable judicial work had been completed. Learned and hard-headed, prosperous and pleasant, his life was, apart from his transcendent achievements as a judge, undistinguished. Personal details, which once may have been of interest, and which excited the curiosity of his contemporaries, have now been reduced to their proper proportions, so that, in the historical perspective, Stowell has become an almost impersonal figure, so closely is his individuality merged in his monumental work. That's the end of the chapter.